My name is Benna Crawford. I am one of the supervisory attorneys in the Children and Families Practice Group here at LAF. And along with Joanne Villasenor, we're going to talk to you about some domestic relations remedies. I'm going to focus quickly on unmarried parents or parenting and child support issues. And then Joanne is going to get into the details on some of the divorce-related remedies. Okay? Okay. So the first thing that I want to talk about, which might seem very basic but is actually not, is how do you establish paternity? Who has the right to be the legal parent of a child? It is not, I can tell you guys now, it is not about biology. It is not necessarily about biology. So I don't want anyone to make the assumption, you know, if there's a man who's the biological father, that he's going to have legal rights to the child. Or necessarily, if there's a woman who is the biological mother of a child, she does not automatically have legal rights to the child. Okay, so there are different ways that you can establish paternity. And this is really dealing with who's the dad. Because I think that that's often, it is not that common that there is a question about who is the mother. So if mom is married when the child is born, the law presumes that her husband is the father of the child. He doesn't have to do anything extra. He's automatically on the birth certificate when the child is born, and there is a legal presumption that the husband is the father of the child that's born to his wife during their marriage. Another way that you can become the father is for both parents to sign what's called a voluntary acknowledgement of paternity, which is a form that gets filed with the state, and that's how unmarried parents get both of their names on a birth certificate. You can have a court order that finds that somebody is the father or the parent, or there are some administrative proceedings. And then finally, there is adoption or surrogacy, which just doesn't come up as frequently for our clients. If it comes up for you, just know you can become a parent through a contract like a surrogacy. What? Okay. So a lot of you are probably familiar with the term custody, especially because this is a term that's still on the order protection paperwork, right? Petitioner is granted legal care and custody, temporary custody of the child. This is the old term. The forms just haven't caught up. But it used to be any court orders that were entered, court judgments that were entered before January 1st of 2016 used the term custody. That's still valid for any of those cases that happened before January 1st, 2016. But anything going forward, custody no longer is a term that we use in the law. It doesn't exist in the statute for parents anymore. So the old law used to be you either had sole custody. It was an all or nothing proposition. One parent had sole custody, which means they got to make all of the decisions for the children, or the parents had to share joint custody, and they had to make all of the decisions for the children together in all medical decisions, all education decisions, all religious decisions, and all decisions about, well, those three areas. They had to make them either together, or if they couldn't make all of those decisions together, one parent got to make all of them. There used to also be the term, which once again is still on the order of protection, as you guys are aware, about visitation. That term also no longer exists. So I just want you to be aware of old terms. We're going to talk about new terms. Okay. So the word custody does still exist, but it is only for non-parents. Only non-parents like grandparents, adult siblings, or step-parents can potentially have custody of children. Parents are going to have, there's a different terminology now. Same thing for visitation. So the old terms are still used for non-parents. The new law talks about parental responsibilities. And it breaks, parental responsibilities includes two categories. So decision-making responsibility, which is what kind of used to fall under custody, and parenting time, which is the new term for visitation. The other thing that the new statute does, when they got rid of custody and moved to decision-making responsibility is it actually it unbundles custody. So now there is, the 4 categories are education, healthcare, medical, and extracurricular activities. And you can have one parent have decision-making responsibility for education, the other parent has decision-making responsibility for healthcare, they can share decision-making for religion and extracurriculars. You can unbundle it and you can mix and match in whatever way is most appropriate for the parents, which can be helpful because it makes it less of an all or nothing proposition. And so each parent could have sole decision-making in one or all of those categories, or they could make some together, some separately. Parenting time is just the new term for the time that each parent spends with the child. And I think the idea is that visitation makes it sound like it feels a little bit more derogatory or less like you have a parent-child relationship if you're just visiting with your child instead of now the term is parenting time. The standard that the court will use to figure out who should have decision-making in which area, who should have parenting time, what that parenting time schedule should look like, is still best interests of the child. And there are a lot of factors that are listed here and that come from the statute for how the court should determine what is in the best interests of the child. And one of those factors is physical violence or threat of physical violence, which can be directed at the child or just at the other parent. So dad is very physically abusive to mom can be one of the factors that the court can look at to determine, what dad's parental responsibility should look like and what's in the best interest of the child. So how can the court restrict parenting time? The court it's a pretty high standard, and the court has to find that there is parenting time, unrestricted parenting time between one of the parents and the child would seriously endanger the child's physical or emotional well-being. So they have to find serious endangerment before you can even get to any restrictions on parenting time. And I'm sure that most of you are probably familiar with the available restrictions on parenting time, like there can be no parenting time at all, which is actually very unusual to see in a domestic relations case. I think you see that a lot more in orders of protection where there are expedited hearings. It is very unusual in a domestic relations case, like a divorce or a parentage case, to see a flat-out no parenting time. There has to be really serious endangerment. More common is supervision or facilitated exchange or other restrictions on the parenting time to remove the thing that's causing the perceived danger, like alcohol or someone else in the home. Okay. One other big change in the law that happened in the last year is a change to how we calculate child support, which makes it a lot harder to do it on the fly in court. So it used to be that you could determine child support based on the number of children that the parties had in common. It was just a set percentage of the supporting party's net income. So you could calculate that really quickly in court. How much do you make? He makes this much. They have 2 kids. He has to pay 28% of his income in child support. The statute changed, July?
I think it was 2016.
Okay. Recently, the statute changed. July 1st, 2017? To what's now called income shares. So it is a more complex formula for calculating child support that is aimed to remedy some of the ways in which the old child support statute did not take into account the specifics of both parties or the income of both parties. Without going into too much detail about how to calculate child support under the new statute, it looks at, you have to know the income of both parents. And taking the income of both parents, there is a table that economists created that said, if you have two parents who have a combined income of $10,000 and they have two children, they are going to spend this much money on their kids based on data from across the country that was sampled over some period of time. They calculated that the cost to raise these two children is $4,000 a month for a household of two parents with a combined income of $10,000. So then based on, in this example, let's say mom earns $2,500 a month and dad earns $7,500 a month. Dad is responsible for 75% of the $4,000 a month. Mom is responsible for $2,500 or 25% of the $4,000 a month. So what does it cost to raise this child? And based on your incomes, you're going to each be responsible for a percentage of that. Now, based on these calculations, dad would pay $1,500 to mom because I'm going to do a bad job of explaining this because I often do a bad job of explaining this. So what I'm going to do instead is later on I'm going to show you how you can run these numbers, and that will be a lot easier. I did this last time I did the training too. There is, what I will say, and at the end I have a link to it, there is on HFS's website, there is a very simple child support calculator that you can go to, or you can direct the survivors that you're working with to go to. They have an attorney version, and they also just have a parents version where it asks some very simple questions about what is your income, how many nights a month do you have with your kids, and it will calculate the number for you.
What's it called? HFS?
Yeah, and HFS, and I have the link at the end of this PowerPoint presentation for all of you. And it is a very simple calculator, both for you guys to use with survivors or for survivors to use on their own. It is very user-friendly. I will say that I've used it. The other thing to know about the new child support guidelines, which is why one of the questions that the calculator asks is how many nights a year do you have overnight with your child, is if the parties are coming close to sharing 50-50, there is a different way to calculate child support that assumes that the amount of money that they're going to spend on their child is slightly more, because they're both going to be duplicating expenses for the kid. Oh, I don't know why it keeps going back. Okay, so here's the website that I was talking about, which will do a much better job than I can ever seem to do on explaining the new child support statute. But if you go to illinois.gov/HFS/child support, you will get to this child support estimator. And I have a screenshot of it here just so you can see how simple it is. You know, what is the number of children? Do you have the majority of parenting time? How many overnights? And then ask questions about income. So it is very easy for people to, either if you're in court with somebody or you're just sitting in your office with them, or you can access it on your phone. There's a mobile version as well, to give people a sense of what their child support would be.
I really can't read because it's so...
You don't like orange? It's not a user-friendly font. So it is, are you looking for the phone number or the website? So it's illinois.gov / some sort of slash HFS / child support.
Thank you.
Yes, of course.
Like Bonna said, I'm Joanne Villasenor. I'm a supervising attorney at LAF. I've been here for a long time, in fact, officially 30 years. I'm going to talk about a few divorce and basics. First of all, let's talk a little bit about marriage. Who can marry in Illinois? Anyone? Same-sex was accepted back in June of 2014. So, and if there's a man and a man that marry, they have the same marital rights to anything that a man and woman had. Same thing with woman and woman, and it's fairly well recognized now. A marriage itself, it's a contractual agreement. It has to be solemnized either in a civil or religious proceeding. According to state law, you have to get a valid license, blood testing, whatever. And the reason I'm bringing that up is because from time to time you may see cases where people say they're married, but maybe they haven't gone through the steps. They have something that does not meet the state or the county standards. So that's something to be on the lookout for. We've actually seen a couple cases like that. And the other thing that's somewhat new, civil unions, which were something a little bit short of marriage, can now be converted into marriage through a license. And then after people are married, oh, I'm sorry.
Civil unions are gone because we do have marriage, same-sex marriage?
No, you can still have civil unions. They still exist. I'm just saying now you can convert them. You used to not be able to. And of course, once you're married, you may wind up getting divorced. So Illinois now has only one basic ground for divorce. You may have had clients over the years that have come in and said that they were treated mentally cruel or abandoned by the husband or that the spouse committed adultery. Now the only ground is irreconcilable differences, which is basically akin to a no-fault divorce. You have to be separated for a period of at least 6 months, and that is like that means that you have met the irreconcilable difference grounds. That 6-month period can be waived if the parties have been separated 2 months and they sign an agreement to waive that. The other things that you need for a divorce are you have to be a resident of the state and county for 90 days prior to filing the case, or at minimum 90 days prior to when you finalize the case. And as I said, the other fault grounds that we used to have in the state have been abolished. In addition to child support, one of the other things that you can get from a divorce is maintenance, or what some people still think of as alimony, which is basically support from one spouse to another. That alimony statute changed a couple years ago. It used to be pretty open as to how it was calculated, and now the statute has changed to have 2 parts to it. Part 1, 504A, is whether the person who is seeking maintenance is entitled to it. And there's a number of factors, there's 14 in all. The court looks at primarily what their standard of living was, what each party's current income is, what their realistic future earning capacity is. So you have to meet that entitlement first. Oftentimes we have clients who have very little income and their spouse does have income, so those are pretty good cases. But we also see parties where both parties don't make that much income. So then the court's going to look and see whether it would be fair for one spouse to pay maintenance to the other. But once that entitlement is met, then the second part of it is to calculate it. And somewhat like child support used to be calculated, you now take a percentage of the person who's going to pay maintenance, 30% of his gross income, and I'm just using his and her for purposes of to make it simple, 30% of his gross income minus 30 or 20% of the other party's gross income. And that will be the maintenance amount. However, there's a little bit of an exception. The recipient of maintenance, her total amount of her own income plus maintenance cannot exceed 40% of the total household income. So that's what they call a cap. The other piece of the maintenance now is that there's a duration amount. If you are married for a very short time, your years of maintenance are going to be similarly short. So in this first example, a 0 to 5 year marriage, the duration is a roughly 20% of the years of marriage. If the marriage has been 20 years or more, it can be, the maintenance can be permanent. And those guidelines, at least in Cook County, have been followed pretty closely by all the judges. And I don't know if there's any questions, I'll move on otherwise. No. And one other thing about maintenance. When you're calculating maintenance and there's child support, the maintenance is subtracted first from the income, and then the remaining income is calculated for purposes of child support. The other issue that comes up in divorce cases are debts and assets. Any property acquired during the marriage, any debt incurred during the marriage is presumptively of the marriage. So any property that the parties buy, whether it's in one person's name or both persons' names, is going to be considered marital property. Any debt they incur, whether if it's a credit card debt in both their names or only in one, it's a marital debt. There are a few exceptions. Inherited property, inherited by, say, the husband, is generally going to be considered his non-marital property, even if it's inherited during the marriage. There are a few twists to that. For example, if the property is inherited and then he does something to convert the property into marital property, I guess the cleanest example would be he inherits a house. It's only in his name, but he deeds the title over to both of their names. They borrow money together to improve the house. That arguably could be then considered marital. Debts usually are of the marriage, but student loan debts usually remain the debt of that person. And they're generally not divided between the parties in a divorce. Sometimes personal injury awards, they might be considered marital, but not generally in the way that we think of like a 50-50 division. So a person is awarded a personal injury award, let's say from a car accident. The other spouse might get a piece of that, but only so much as the award went to cover that person's pain and suffering, or if they took care of the injured spouse. So again, it's sort of, it's not cut and dry, it's not black and white. The other big marital property is pensions and retirement accounts. And I had said that anything that you acquired during the marriage is marital. Well, portions of pensions and retirement accounts that accrue during the marriage, even if they started before the marriage, those portions from within the marriage are going to be considered marital. The only exception, and there's always exceptions, are pensions that are in pay status at the time of the marriage that were accumulated by the spouse prior to the marriage. But that pension and pay status could be a portion for maintenance. And I don't know if we have time for me to get into, there's different types of pensions. When I say pension, a lot of us think of the amount you get upon retirement per month. That's what's known as a defined benefit plan. The other type that we are more familiar with, a 401k, which is a fixed sum of money, that's considered a defined compensation plan. There's also other types of government pensions, railroad pensions, which in some ways take the place of Social Security benefits. There's military pensions, and there's also pensions from other federal employees like the post office. So whenever you're talking to a client about pensions, you need to kind of ask all the different questions. Where did they work? Was there a pension? Where did the spouse work? And you'll become familiar with different types of jobs that have pensions. If they work, for example, for the city of Chicago, there's going to be a pension somewhere. If they're a teacher's union pension, there may be some other pension. So it's just a good idea to just sort of keep that in mind, either for the person you're interviewing or talking about their spouse. And in talking to a client, you can ask these different questions. Who's the employer? Does the spouse belong to a labor union? Because they might have a pension from that. You can look at pay stubs. A lot of times the pay stubs will have some deduction for a pension. The W-2s, there's a box 12 that's marked off if there's a retirement account. Box 13, box 12 can have other codes for other types of deductions that can be retirement. I'm going to skip through, but I think your material has this. But if you look, I'm just going to point out one thing. The retirement account, this is box 13. And box 12, these are box 12 codings. And that, I think in the materials, I put in a sheet with the different codings because it's just good to know. Just good to be looking at it and keep it in mind. The final property issue to look at in a divorce are houses. So the way to look at a house is what is the equitable value of the house. The equitable value is the market value today minus whatever's left on the mortgage. That's what we call equity. In some cases, maybe our client is living in the house with the children, so the goal would be to keep them in the house and to avoid having them have to sell it or having them have to pay half the equity to the other spouse. Sometimes they're not living in the house, and it's to the client's advantage to sell it and to get some money from it. So that's a question to ask. The other thing to ask is, what's the status of the mortgage? Is it current? Who's paying it? Does the mortgage include the property tax installment and homeowner's insurance, or do they have to pay those separate? So those are just things to be on the lookout for, and when you're talking to clients to find out. And one other thing with mortgages, as I said earlier, even if the mortgage is only in the other spouse's name, if that property was acquired during the marriage, it's still marital property, and there's still rights that the client has to that property. Same with the title, if the title of the house is only in the other spouse's name. I guess that was it. Any questions about property?
Just
Yes.
one quick one, and I probably know the answer. If he owned the home before they were married 30 years, she paid all the bills, but her name was never added on anything, does she have any rights?
Well, maybe not, because there's a couple cases out there that talk about living in a house that's owned by someone else and helping them pay the mortgage is akin to paying rent. You'd have to pay rent somewhere. So you don't necessarily get an ownership interest, but you might if that mortgage was refinanced and used your client's income to get a better interest rate, or refinance to take out additional money to make large improvements on the home. So generally, maybe not, but it's always good to ask and to just see how that was owned and what happened during the 30 years. Any other questions?
I have one.
Yes.
For the grounds for divorce, so if it's a domestic violence situation and the spouse doesn't want to sign the 2-month waiver, our client would have to wait 6 months to divorce that
Yes.
spouse.
And it's 6 months from date of separation to the date that the case is proved up. So it might be that by the time the case is heard, the 6 months will pass, especially if the divorce has been filed and it's been contested. So, yes.
We have a lot of problems with people who get paid in cash. And is there anything you can suggest for people working with people like that?
I mean, there's different things you can look at. You can look at if they bought a house, what did they list on the purchase information as their income? If they took out a loan, so that's one way to find it out. You can look at standard of living, credit cards. What credit cards do they qualify for? So you have to do some investigation. You can also, I always ask clients, well, what was he bringing home? What were you doing? Sort of like standard of living, like did they go out, did they go on vacations, did they have a savings account, did he send money to family, and how much was it? So you just have to ask a lot of different questions to try to put together what that person might be making. If it's an industry that is heavily cash industry, you could also look in economic journals or online to see what that industry, what the income is for that industry. Like cab drivers, for example. It's hard. It's very hard. But with investigation, you'd be surprised. Clients will know more if you ask them a lot of different questions that they don't even realize that that's putting it together.